What landmark legal cases redefine layoff protections? Imagine losing your job and feeling unsure if the process was fair or if your rights were protected. Over the years, some key court cases have changed how layoffs are viewed and handled legally. These cases have helped make sure employees are treated fairly and protected from unfair treatment during layoffs. One of the earliest important cases is called Griggs versus Duke Power Company. This case from 1971 set a rule that employment practices cannot unfairly target minority workers without a good reason. It made clear that layoffs or job decisions based on policies that unintentionally discriminate are illegal. So, even if a company says a policy is neutral, it cannot have a harmful impact on certain groups without a valid reason. Another case is Muldrow versus the City of St. Louis. This case from recent years expanded what counts as an unfair employment action. It said that not only firing or demoting someone counts, but also actions like giving someone extra work or treating them badly. If these actions would discourage a worker from speaking up or taking part in protected activities, they are considered harmful enough to be illegal. This broadens protections around layoffs and workplace treatment. In 2020, the Supreme Court decided Bostock versus Clayton County. This case confirmed that discrimination based on sex, including being transgender or gay, is illegal under federal law. It means that workers cannot be laid off just because of their gender identity or sexual orientation. This ruling makes sure everyone has equal protection against unfair layoffs based on who they are. The case Thompson versus North American Stainless from 2011 added more protections. It said that if an employee is fired because they or someone else filed a discrimination complaint, that is illegal retaliation. This means layoffs or firings meant to punish employees for protected activities are against the law. It helps prevent employers from using layoffs as a way to punish workers for standing up for their rights. Finally, Pennsylvania State Police versus Suitors from 2009 addressed what happens if someone feels forced to leave because of harassment or discrimination. The court decided that if a worker resigns because the work environment is intolerable, it can be treated like a wrongful firing. This protects employees who feel pushed out rather than officially laid off. All these cases have changed how layoffs are viewed legally. They make sure layoffs are not based on discrimination or retaliation. Employers must be careful to treat all workers fairly and document their reasons for layoffs. Employees now have stronger grounds to challenge unfair layoffs if they believe their rights were violated. These legal decisions help create a fairer workplace for everyone.